So the anti-defection law has been in much discussion, keeping in mind the recent political switches that have happened from one political party to another, especially from one of the regional parties. What is your thought on the anti-defection law? What are the circumstances under which the law becomes operative? And also, please explain the concept of when one political party is said to have merged with another political party.
As far as anti-defection law is concerned, according to me, it has been a non-starter in this country, because even when the defection was held to be valid, or it was said to be that a MP has lost his seat in the particular house, the Supreme Court by a judgment has held that that loss will only be from the present seat, and he can again get elected to the same house by joining the other political party. So that according to me was a very wrong adjudication, because it actually encourages a person to defect by leaving one political party and joining another political party and losing his seat and contesting on behalf of the other political party in the same house. So at least the defection should be valid for the entire duration of that particular house from which he is defected, because the law on anti-defection does not talk of any period of disqualification like it does as far as when you are convicted of a criminal offence is concerned. There is a period specified which says period of conviction plus 6 years. So this is the first violation of the principle of anti-defection which is happening in this country. What has happened in this case of this Aam Aadmi Party, I think, is also a little bizarre, because the only way 2/3 of the members of a house can join another political party is by saying that the party itself is merging with the BJP. So the claim in this case for the purposes of merger should be that this Raghav Chadha and this rest of these 7 people should make a claim that because we are the real Aam Aadmi Party and we have decided to join BJP, so now there is a merger between Aam Aadmi Party and BJP, and accordingly the anti-defection law will not apply. Because the anti-defection law says that if there is a claim for merger, then at least 2/3 members should be merging with the other political party. So the prerequisite for a merger is that firstly there should be a claim that the party itself is merging with the other political party. If you don't make that claim of merger of the entire party, then merely because 2/3 of the members of the Rajya Sabha decide to join the BJP itself, according to me, is not a ground to justify that a merger has happened. Because the prerequisite for a merger should be that the claim, at least the claim should be made that we are the real Aam Aadmi Party and we want to join the BJP. If there is no such claim, then merely because 2/3 of the members have agreed to join will not be a justification to say that this actually is a merger between Aam Aadmi Party and the BJP. So according to me, this also is contrary to the spirit of the anti-defection law, and this merger under any circumstance cannot be justified, and these members should lose their membership to the Rajya Sabha, and according to me they should not be permitted to contest for at least another 6 years, which is the normal duration of the membership to the Rajya Sabha.
So one question that comes to my mind is that if 2/3 member of Rajya Sabha or the upper house of the parliament have merged or gone to the other side, defected from one political party and gone to another side, why should this not be termed as a merger under the 10th schedule?
This could be a merger if the claim of these 2/3 members was that we are the real Aam Aadmi Party. And accordingly, now that we have decided to go, we fulfill the requirement of being 2/3 of the members of the Rajya Sabha of the political party, and thus we can claim ourselves to be the original Aam Aadmi Party. What has happened in this case is there is a split in the Aam Aadmi Party, and one splinter, which is not claiming it to be the real Aam Aadmi Party, has merely joined the BJP. So the splinter can't be said to be the party merging, because the requirement in the subclause 1 is that there should be a merger of a political party, and merger of a political party can only happen if the members of that political party claim that we are the real Aam Aadmi Party and we are now going there. If a split of 2/3 is happening, then they do not qualify to merge with the BJP as Aam Aadmi Party merging with the BJP. That is a prerequisite to to avoid the rigors of 10th schedule. Even if it had been a fanciful claim that we are the real Aam Aadmi Party and we are now joining the BJP, then also at least there would be a tribal issue. But here they don't even claim that they are the real Aam Aadmi Party. If they are not the real Aam Aadmi Party, then there cannot be any question of merger. And it is merely a splinter of Aam Aadmi Party which has joined the BJP, which is not the purport or the intent of the 10th schedule.